female lawyer on the entire west coast of the United States. She moved to San Francisco, leaving her children with her parents in San Jose. Now, in 1879, a law was enacted to allow qualified female attorneys to practice in any federal court in the United States. And Belva Lockwood was the first woman admitted to practice before the U.S. Supreme Court. That same year, 1879, Hastings Law School. Anybody here gone to Hastings? Okay, you guys, listen up. Hastings Law School is a branch of the co-ed University of California. It opened in 1879. It was the first and only law school in the state. Foltz and fellow feminist Laura Gordon registered and attended 3 days, and then they were informed that women were not allowed admission. The rustling of their skirts, they were told, distracted the other students. So Clara devised a brilliant two-pronged strategy, a constitutional amendment and bringing a lawsuit against Hastings. Prong one, during the Constitutional Convention, Foltz wrote and proposed the Women's Employment Clause, which passed. And then it was ratified by popular all-male vote when the whole Constitution was ratified. Anyway, this read, quote, "No person shall, on account of sex, be disqualified from entering upon or pursuing any lawful business, vocation, or profession," close quote. And that's still in the Constitution. Okay, so that's the furthest out that, the closest thing to an equal rights amendment that existed at the time, or even now. So, okay, prong two, Foltz and fellow feminists sued Hastings for writ of mandamus. Now this is in your written material. It's Foltz versus Hogue. It was her first published opinion. And our law school has a complete set of California, so I'm going to pass this around. This is 1879. It put a little sticky, okay? And so this is Foltz versus Hogue. So this book is 140 years old, and that's because the case is that old. So for those of you, how many of you people only studied case law in digital form? Yeah. Okay, well, when I went to law school, it was all hard copy. So anyway, you really needed those books. Anyway, so the court ruled in Clara's favor. She argued that it was an anomaly that women could practice in any court in the state, but were excluded from the state's only law school. Hastings appealed the ruling, and Foltz studied for and passed the California State Supreme Court bar. So there's two different bars at that time, in order to argue her case. And then she quotes herself as saying, "Worn and spent with the heavy cares of my growing children, I studied day and night." Okay, now you have that Supreme Court case in your paper, so I'm not going to go into it in detail. But the attorney for Hastings argued against letting women in, because he said if you were to allow women into the law school, you would make women eligible to every non-elective office in the state. That was his argument. And Clara came back, "Mandamus is the proper and only remedy. The University of California is a state institution. The Hastings Law School is a department of the state university and subject to the general laws governing the university. Discretionary power to regulate and manage cannot be used to exclude one class of citizens while open to others. The power to regulate is not the power to prohibit. The bylaws and regulations of Hastings are not to be contrary to, nor inconsistent with, the laws of the state." And so the judge says, yeah, you win. And basically, he says, "The same general policy which admitted females as students of the university opened to them as well the doors of the College of Law. Judgment affirmed, remitted her forthwith." And Clara considered this the greatest victory of her career. However, she was impoverished at the end of all this, and so she was never able to afford to go to law school. She had to go back to work as an attorney. In 1879, she turned 30 years old. Okay, so she's done all this before she's 30. She sued Jeremiah for divorce on the basis of desertion, but she told everyone her husband had died suddenly. And that year she was appointed the first female clerk for the state. Then she worked as a paid orator, and in 1887 she was the first woman appointed to statewide office, the Normal School Board. In 1890 she founded a club called the Portia Club in San Francisco, educating women in the law, and then they would go to these different courtroom situations where a woman was a defendant or was a victim or was all by herself one way or another to support the women. In 1891, she created the California parole system, which was passed into law in 1893. 1893, she attended the Chicago World's Fair, which was also attended by my great-grandfather, William Moses Cox Howell. He was going to the Parliament of Religions, but I just happened to have a souvenir from the 1893 World's Fair. So maybe they met, you know, I don't know. I'm going to pass this around too. At that fair, she proposed for the first time the public defender system. She spoke of the right to counsel enacted in the federal Constitution, reenacted in almost every state, which guarantees, this is someone who attended writing notes as she spoke, which guarantees to the accused certain rights. He may have a speedy trial, he may have a trial by jury, he may meet the witnesses, he may have the witnesses in his behalf, he may have counsel for his defense. It is a grave question whether Congress or the legislature may add to any of these rights a condition that if the accused can pay, a condition that renders the guarantee inoperative. So again, she says for every public prosecutor there should be a public defender chosen in the same way, paid out of the same fund as the public prosecutor. Police and sheriffs should be equally at his command, and the public treasury should be equally open to legitimate expenses. She did not limit her call for exact, equal, and free justice to the courts, that which she knew firsthand. She said a public defender should exist anywhere if there's a public prosecutor, at every courthouse in the land. So 70 years after Foltz spoke at the fair, the United States Supreme Court decided as much in Gideon versus Wainwright. And that very case has now been called into question by Clarence Thomas on the U.S. Supreme Court. I just read it this morning. Okay, by 1900, every state had passed legislation granting married women the right to keep their own wages. And then in 1903, her oldest child died. In 1910, she was appointed to the Los Angeles District Attorney's Office. And in 1911, she was a leader of the suffrage movement that led to adoption of a California constitutional amendment recognizing women's right to vote. She wrote the Women's Vote Amendment for California. She actually wrote the amendment that was passed. And she used her earlier really simple technique of keeping the voters' right statute exactly the same, but just removing the word male and substituting the word person as a qualification to vote. And in 1912, the first public defender office was established in Los Angeles. And then in 1920, when Clara was 71 years old, women were finally guaranteed the right to vote, the 19th Amendment by the U.S. Constitution. And in 1921, the Foltz Defender Bill that established the public defender system was adopted by California and